tonight's event, co-hosted by the LSE Department of Gender Studies and the LSE Law School on gender and the law, how law matters to gender or how gender matters to law. My name is Sumi, Madhok, and I'm Professor of Political Theory and Gender Studies at the Department of Gender Studies, where I'm also the head of department. And it is my great pleasure to chair this evening's event. Before I begin the proceedings, I'd like to give out a wonderful shout out, actually, to my wonderful events colleagues at LSE Gender. This is the second last event of the term, and as you can see, this too is a huge sellout and amongst the hottest tickets in town. So can you please join me in giving a big hand to the team that makes magic happen, event on event. Sandra Wilson and Nicola. So let me introduce you to our wonderful panel. As you can see, we have an hour and 25 minutes or so at our disposal, and we've got a very packed agenda. So our wonderful panel of experts have thought about the question we've set ourselves today for very long and very hard, and I will introduce them in the order that they will speak. Professor Nicola Lacey, on my extreme left, is School Professor of Law, Gender and Social Policy at the London School of Economics. She also sits on the advisory board of the LSE Department of Gender Studies. A fellow of the British Academy, she won the UK Law Teacher of the Year award this year. Her publications include Women, Crime and Character, from Maud Flanders to Test of Worlds, The Prisoner's Dilemma and In Search of Criminal Responsibility. Dr. S.M. Rodriguez, on not so far left to me, is Assistant Professor in Gender Rights and Human Rights and the MSc Program Director for Gender Rights and Human Rights at the Department of Gender Studies at the LSE. Their recent monograph, The Economies of Queer Inclusion, Transnational Organizing for LGBTI Rights in Uganda, was shortlisted for the Best Book Prize by the American Sociological Association. Professor Susanne Baer, on my right, is Professor of Public Law and Gender Studies at the Humboldt University of Berlin, where she's been Vice President and also the Director of Center for Gender Studies. A Fellow of the British Academy, she is Centennial Professor at the LSE, and between 2011 and 2023 was one of the 16 Justices of the Federal Constitutional Court of Germany. She is most recently the author of The Rule of and Not by Any Law on Constitutionalism. So here's our wonderful panel, everyone. The order of events is as follows. After each of the panelists have spoken for about 15 minutes, there will be time for audience Q&A. So that will be your chance to ask our wonderful panelists questions, clarifications, and any comments, very brief comments that you might have. And after that, there is a reception in the honor of our panelists, to which all of you are very warmly invited. And the reception is just outside this room. So can I ask Nicola Lacey to set us there? Thank you very much.
Thank you so much. Thank you for that particularly warm and generous introduction, and very warm welcome to all of you from me as well. It's lovely, especially to see some of my students here, and for those of you in Susanne's and my Feminist Legal Theory seminar this morning, I'm quite glad to be standing up because it's been a long day, hasn't it? So I'm especially conscious of your having turned out this evening. So it's always so good to do collaborative events with Gender, and we've had a long and close relationship ever since I came to LSE in 1998. Now, I'm a lawyer, so I'm of course going to start by breaking the rules. And I'm going to reverse the order of the questions. And I'm going to talk, first of all, a little bit about how gender matters to law, then a little bit about how law matters to gender, and then I'm going to sort of take a couple of case studies. And very much what I have to say is shaped by the fact I'm a criminal lawyer. So you should take that as a plea in mitigation, as it were. So gender, why does and how much does gender matter to law? Now, I'm well aware that if I were to stand here and say, well, gender doesn't really matter to law that much, I would be quite rightly hounded out of the room, because, of course, gender is absolutely fundamental to the way law works, to its meaning, to its impact. And that's for a very, very obvious reason, which is that law is socially embedded, and gender is, pervasive and shapes legal relations power within the legal context, just in the way that it shapes power and institutions much more generally. But the way in which gender and sex affect law, and I'll use them pretty much not interchangeably, but I actually find it sometimes quite useful to use both, is instructive, I think, and has some quite important consequences for legal education. And it's this, that it's perfectly obvious, even to people who aren't feminists, that sex gender is has a massive impact on the content of law. So just to take the most obvious example, we are all in this country, and basically in pretty much every country, given whether we like it or not, a sex identity at birth. We can't opt out of it. We can change it at an enormous amount of cost of various kinds, but we're given that. Now imagine any government decided to give an ethnic identity or religious identity or any other kind of identity ascribed at birth before we know anything about that person. I think we know what the reaction would be. So it's a very fascinating thing, this sex gender dynamic, because, or phenomenon, perhaps I should call, because we live in the sort of the truism of Henry Maine, the famous legal historian, that we've moved, from a world of status-based organisation to a world of contract where we're all formally equal. But sex, gender, is the last remaining imposed status, and it has enormous consequences for us. That sex identity that we're given at birth, whether we like it or not, then has legal consequences for us through our lives. I'm not saying that that's the most important one, but it's a good example of why nobody in their right mind could possibly argue that sex gender isn't pretty fundamental to law. And of course, equally, on the surface of the law, in family law, in my field of criminal law, there are loads and loads of ways in which, in medical law, I'm looking at Emily Jackson here, there are loads of ways in which just on the surface of legal rules and arrangements and protocols, there is various kinds of gender differentiation, gender assumptions, and so on. And very often they are still, even in 2025, explicit. Despite the fact that we've had an Equality Act in this country for basically all of this century, and we have sex discrimination and equal pay legislation for a lot longer, those explicit differentiations persist. But that isn't the point I really want to make here. The point I want to make is that in order to really reveal the power of gender dynamics in law, we have to look beneath the surface of the legal rules and principles and arrangements. We even have to look, although it's important to look at the personnel of the legal system, of course it is, but we have to look beyond that as well. We have to dig. We have to look at the assumptions on which not just legal rules and principles and arrangements and institutions are built, but also just even the really formally neutral protocols and methods that the law uses. So we have to ask questions about how the law implicitly conceives its subjects, how it constructs the idea of what counts as a good legal argument, what legal arguments, what facts can be heard in a courtroom. And these things are much harder to deconstruct. It is about deconstruction, really. So basically, it has to be careful work, and it has to be done in what, in this country we call a sort of socio-legal way. In America, they call it law and society way. I'm sure what you call it in Germany, Susanne, but what? Is it a very long word with a lot of syllables? So it's hard work, and I'm emphasising that because I think sometimes, on the whole, in LSE, we have very sympathetic colleagues on the law and gender front in the law school, but a typical reaction, let's say, from one of my private law colleagues, or I teach contract law, so there isn't many gender issues in contract law, property law, whatever. Well, think again. because the whole basis of contract law, property law, is, which are foundations of power in society, are, affected by gender. Of course they are, but you have to think about it. And I think this is an important point, because there's a very facile way of dismissing law and gender studies and feminist theory, which is to say, oh, it's just a political view. It's not a political view. It's a deeply thought out intellectual view, which raises some very difficult questions to which we don't have all the answers, which we're still thinking about and puzzling about. Questions that we've debated in our feminist legal theory seminars already this term, debate every year with our students, about how we can build that consciousness of the power and influence of gender in law into a way of countering it while acknowledging it without embedding it, re-embedding it. These are really, really difficult questions which we still struggle with. So in terms of gender importance for law, fundamental, sometimes obvious, often not obvious, just as important, perhaps even more important when it isn't obvious, big intellectual project to try to excavate the influence of gender dynamics on both the methodology, the modus operandi of law, and the reality of law and the impact of law in people's lives. So, second question, your first question, how law matters to gender. Now, obviously, it would be very stupid of me to say, well, law doesn't matter as much to gender as gender matters to law. That would be facile. But the honest answer to that question is yes and no. Law matters tremendously to gender, but it has its limits. And there's Carol Smart, the very famous feminist sociologist and lawyer, argued in her book Feminism and the Power of Law in 1989. Law has a kind of siren call. It's very appealing, particularly to governments, to reach for laws as a solution to social problems. It's very appealing, it's very tempting. You don't need to build new infrastructure. You've already got the legal system, you've got the courts, you've got, in my field, you've got the police, you've got various regulatory agencies. It looks like a quick fix to a whole range of social problems, which it often isn't a fix for. Because as we also know, and of course, underpinning the importance of gender for law is the fact that the embeddedness of law's gender has to do with deep social dynamics, power distributions, histories, mentalities, which cannot be changed by fiat. And at the end of the day, articulated law is as a kind of fiat. It promises a kind of alchemy. It turns something illegal, or makes somebody liable. It gives somebody a power or a capacity or an immunity. But it has to be interpreted first. It has to be enforced first. And that poses limits. Now, I think my view, my very qualified view on, as Carol Smart put it, how far feminists should be lured by what she called the siren call of law, which is obviously implying there's a bit of a danger that you get washed up on the rocks where the sirens are singing to you, is probably shaped by the fact I'm a criminal lawyer. So criminal law is a really, I'm going to suggest it's more so than other forms of law, but perhaps it's sort of an instructive case study. It's an ambivalent thing. So criminal law, on one hand, invokes the power of the state in one of its most, coercive and mighty forms, in order to underpin certain common goods and interests. And of course, we all know one of the truisms about criminal law and crime and criminal justice, which is highly variable and contingent, but we know that on the whole, people on the receiving end of crime tend to be disadvantaged, but also that the people on the receiving end of criminalisation tend to be disadvantaged. So it's a very, very complicated tool to use. And for that reason, we have to be very careful about invoking criminal law as a quick fix for problems. Now, criminal law is full of very, very important and non-obvious case studies for the importance of gender to law. So let's take an example which has been very well debated, and I'm sure you're all aware of, which is the way in which the doctrine of self-defense has been framed in many countries, particularly common law countries, has made what we might call a sort of slow burn, non-immediate response to a threat very difficult to bring within the doctrine. This obviously advantages relatively powerful victims. And there's been a big effort across a whole number of jurisdictions to reframe the self-defense doctrine so as to allow it to apply in cases of long-term domestic abuse, for example, which before, it won't surprise you to hear, women got pushed into the mental incapacity defences because they didn't come within self-defence or provocation or loss of control. And that's been a thoroughly good thing, but it just reminds us that there is also always an ambivalence, because the more you relax the ambit of the defences, more you let, can't just say, oh, and this is basically for victims of domestic abuse, by the way. It applies to everybody. So the more liberal the defence is, the more other people can take advantage of that. And in particular, there's been a big debate, which many of you will be aware of, about the invocation of law as a solution to sexual and domestic abuse, gender violence. And there's a big debate, and so people like Janet Halley at Harvard and I believe Prof. Warren over at King's, about so-called carceral feminism, the idea that feminists, as a left-wing criminal lawyer, I'm often subject to the butt of the joke that you progressive criminal lawyers, you're all for decriminalisation until it comes to corporate crime and crime against women. And there's a grain of truth in that. But what I'm saying is we have to be really careful to not just say, no, of course that means we can't use law, but to rethink and to think carefully about how law can be used. So in my field, one of the things I would argue about the invocation of law in relation to gendered violence is that we should not throw the law out, but we should question whether a legal enforcement model has to include an automatic resort to penal coercion as a response. So I think there are all sorts of ways in which you can rethink, imaginatively recalibrate what it means to set down a legal standard, which the legal system is serious about, but without saying that you then necessarily bring in all the traditional penal responses, which I think have a lot of downsides. So I'm out of time. I've got plenty more to say about that, but I will stop, and thank you so much. Thank you.
Okay, so this probably flows quite well. We'll see. I mean, I think so. So I have an article that I've been working on, and it's forthcoming in Feminist Legal Studies. And I know Professor Lacey has heard it, and of course, Professor Madhok. But it begins with an ethnographic story where I recount how one night in Kampala in 2017, I found myself climbing into the back of a military-grade police truck, surrounded by rifles and officers, after trying to intervene in the arrest of a queer friend. The incident began outside of a nightclub where a group of us, mostly queer, mostly gender nonconforming, had been dancing. When a man attacked a masculine-presenting woman in my group, the police arrived, and instead of detaining the man, they arrested her. She was a visibly queer person who had defended herself, and I did not find success in de-arresting her. So I joined in the truck and accompanied her to the jail for legal observation, documenting her injuries and leveraging my relative privilege to ensure that she didn't find greater mistreatment than the fact of arrest. At the station, the logic was clear. The officers joked that perhaps this kind of woman was stronger than the man and implied that she required different handling. The remark was not about the fight at all, it was about gender. Her body and being, read as gender deviant, was already criminal. The man's injury signified victimhood, and her equally injured body signified queer threat. What took place that night was not merely an arrest, but an act of translation, an instance of how the state reads gender and sexuality through the code of criminality. Since then, I have considered two kind of comparative situations, one of which is within family law, but both of which have kind of Black, queer, and trans victims of violence, where they've encountered the same familiar logic, but in different registers with CPS, Child Protective Services, and with medicalized detention. All showing how gender nonconformity becomes the interpretive framework through which claims to harm are assessed. So across these kind of vastly different moments, the same pattern emerges where queer and trans people are denied the position of the harmed because we're already legible as the harmful, the criminal. The law's question is not what redress is required according to what happened to you, but is redress required according to who you are? This talk asks what kind of system produces that reversal from victimized to perpetrator, and I'm calling it the meta-language of criminality. So when Evelyn Brooks Higginbotham introduced African-American women's history and the meta-language of race in 1992, she named something that exceeded the category, both category and experience. Race, she argued, was not merely one identity among others, it was the grammar through which all social difference was rendered intelligible. It spoke about and lent meaning to gender, class, and sexuality. In other words, Black racialization functioned as a global code that organized what could be seen, felt, and known. It blurred distinctions between content and structure. Race was not simply what the law addressed, but the language through which the law itself was written. Later, decolonial theorists expanded on this as the colonial difference, the construction of human and non-human through the technology of race, through which gender may not be extant or accessible for those coded Black or non-human. For Higginbotham, experiencing life in a settler colony, race does not merely intersect with other hierarchies, but overdetermines them. Bailey and Stallings note that attention to diaspora and transnationalism remains limited in Black feminist and queer scholarship on sexuality. The meta-language of criminality fills precisely this gap. So by situating the analysis within post-colonial and majority Black legal contexts, I trace how criminalization, beyond particularized applications of criminal law, becomes the semiotic field through which Black, queer, and trans subjects are perpetually rendered suspect, even when seeking redress or support as victims. In this sense, the meta-language of criminality extends Higginbotham's analytic beyond US law to show how the colonial juridical order continues to deploy criminality as a meta-language, one that finds its expression through the lexicon of gendered and sexual deviance, translating racial and national anxieties into legible forms of threat. Criminality is then a semiotic regime, not a descriptor affixed to an act. It is the interpretive code through which the state and society make gendered and sexual difference legible as danger, deception, or disorder. In this interpretive order, even victims become legible as perpetrators, gender-conforming harm doers are neutralized or justified in their violence. That was the slide that went with that. When Evelyn Brooks Higginbotham introduced the meta-language of race, she offered a way to understand race not simply as a social category, but as a system of signs, a structure that organizes meaning. In semiotic terms, race operates both as signifier and sign system. It allows the settler society to apprehend who belongs, who threatens, who deserves protection, and who does not. This is what Higginbotham meant when she wrote that race supplies the interpretive logic through which other forms of social value acquire significance. Understanding race as a semiotic structure clarifies its durability. It persists not because people continually reproduce racist ideas, although of course they do, but because everything, law, desire, knowledge, even morality, is already written within racialized code. When race sets the terms of intelligibility, distinctions like gender or class appear to exist independently, even as they are organized by race's deeper grammar of difference. In Higginbotham's terms, race is not merely visible in representation, it shapes what can be represented at all. In post-colonial contexts where racial difference is less materially imagined, criminality enjoys race's semiotic function. It performs the same organizing work, structuring who can be read as innocent, victimized, or human, and it is already always racialized. Criminality is not the act of breaking the law, but the condition of being readable through suspicion or risk. Gender and sexual deviance supply the signifiers through which this condition is interpreted. In this way, the semiotic power that clusters around racial phenotype for Higginbotham here circulates through gender criminality, binding gender, sexuality, and nation into a single field of meaning. There's likely another slide. Yeah, no, but we're on time now, so that matters. It was under empire that moral difference, bodily difference, and juridical difference were made to signify one another. European colonial presence across the Caribbean and Africa did not only export penal codes, it exported a way of reading the body. Criminal statutes against sodomy, vagrancy, indecency, and idleness were never about discrete acts. They were instruments for assigning legibility, for deciding whose life appeared as order and whose as threat. As Jackie Alexander reminds us, the colonial state's most enduring export was not law itself, but law's sexuality, its capacity to reproduce European mores through governance. In Pedagogies of Crossing, she shows how post-colonial nation states inherited the colonial state's moral architecture, the presumption that sexual propriety anchors national legitimacy. In this way, the erotic, which for many African and Caribbean cosmologies once held spiritual and communal value, became the index of civilization. Law remade it into evidence. Within this regime, racial difference was no longer only visible on the surface of the body. It was moralized through sexuality and gender performance. After formal independence, that moral architecture didn't vanish. It was re-articulated through heteronational respectability, through the coloniality of gender and the enforcement of heterosexualism as a system of governance. Therefore, sexual and gender deviance becomes treacherous to the nation state as it reveals an individualized moral sovereignty. The respectable citizen was imagined as heterosexual, reproductive, and modest, while sexual excess and gender nonconformity were cast as betrayal. The legal continuity of colonial statutes against sodomy or buggery, such as the 1861 Offenses Against the Person Act, ensured that post-colonial independence could appear juridically modern while remaining epistemically colonial. We see the height of this today as Trinidad and Tobago must come to the Privy Council in London in order to repeal their colonial laws against buggery. And as legal battles pervade the African continent for the right to express sovereignty, as the right to kill your own people, clashes against the right to express one's individual sexual sovereignty. And as settler colonies, such as the United States, channels its ever genocidal domestic intent against its perpetually trafficked population of African-descended peoples, especially if they identify as queer or trans. As such, criminalization has become a technology of post-colonial belonging, a way to define the nation through the policing of difference. And this is where the meta-language of criminality enters. It inherits race's interpretive power, but it hides behind the idioms of culture, morality, and protection. To be queer or gender nonconforming in these contexts is not simply to risk prosecution. It's to become a sign within a national semiotics of risk. Criminality does not follow from behavior. It is the inherited language through which coloniality continues to make the racialized body legible. That's to say, regardless of the particular instance of harm, one's criminal status as Black gender deviant precedes the reading of the incident. If colonial law created the grammar of criminality, then the post-colonial state sustains it through everyday circulation of suspicion and the ever-developing technologies of surveillance, including nationalized political organizational registration, social media monitoring, biometric scanning of pornographic access, etc. In encounters with police, social workers, healthcare providers, or even neighbors, the queer or trans person is positioned as a suspect before a word is spoken. The law does not need to intervene directly in response to discrete activities. Its interpretive framework increasingly migrates into ordinary life with the heightened surveillance of our times. To understand how this operates, we can return briefly to semiotics. The signifier in this system is not the act of offense, but the embodied cue that suggests one: the masculinity of the woman, the effeminate man, a trans person whose documents do not match their appearance. The signified is threat, risk, or deception, and the sign, the completed social reading, is criminality itself, a figure of risk that moves through the world attached to certain bodies. Suspicion adheres, clinging to those already marked by moral difference, and it attaches to gesture, tone, and proximity, announcing criminality affectively before it's ever named. This stickiness has material effects. When a queer person reports an assault, the complaint becomes reversible. When the reporter becomes the accused. When a trans woman seeks medical care, her body is read as a moral hazard. Her suffering is self-inflicted. Even when statutory law does not criminalize her, such as lesbians assigned female at birth in Jamaica, for example, criminal suspicion substitutes for law, enforcing order through non-enforcement. These are not simply failures of procedure. They are the intended outcomes of a semiotic system that requires certain bodies to signify threat in order for others to signify innocence or safety. Importantly, this semiotic order also mediates class. Education, employment, and respectability can sometimes delay suspicion, but rarely dissolve it. They are reinterpreted as deceit or moral arrogance, reinforcing the idea that queerness hides behind privilege or pretense. The wealthier or more articulate the queer person, the greater the perceived fraud or socio-political treachery. While class can, of course, provide material supports to protection, such as privacy, so like a taxi rather than walking home, or a home rather than rough sleeping, it's nevertheless mediated or spoken through by the language of criminality within racialized contexts. This is therefore what motivates national politics against financially empowering queer populations and inspires anti-homosexuality laws today. This is why my work has looked at protection and suspicion as co-constitutive rather than oppositional, especially through former articulations on invulnerability, or the relationship between invulnerability and vulnerability, which I co-authored with Liat Ben-Moshe and H. Rakes in 2020. The state's promise of protection is always already predicated on the capacity to identify and therefore produce the suspect. To extend protection to some, others must remain legible as threats. In the post-colonial order, that logic is racialized, abled, and gendered. The insecurity response to queer, trans, or gender nonconforming people provides the affective evidence that protection is necessary in the first place. Criminality, in other words, is the shadow grammar of care. I care about women, so I criminalize threats to my understanding of womanhood. I care about children, so I criminalize those who have experienced fearful childhoods. The task, then, is to read law not only as text or institution, but as a producer of meaning. This is the insight shared by the Black feminist legal genealogy that precedes this work. So Pauli Murray's formulation of Jane Crow in the 1960s revealed that the law constructs femininity and race as codependent categories of exclusion. In the 70s, Florence Kennedy described this process as niggerization, the transformation of marginalized people into symbols of threat whose subordination sustains social order. Kimberly Crenshaw in the 80s named intersectionality to expose how the law fragments experience to preserve its own coherence. And Evelyn Brooks Higginbotham extended that critique by showing that race itself functions as a meta-language. So my proposal for a meta-language of criminality extends this tradition into diasporic terrains, where coloniality of gender and nation continue to define who may be read as innocent, as victim, or as human. In these contexts, law's violence is not exhausted by punishment. It resides in meaning, in the way that suspicion adheres and protection is withdrawn. A queer Black feminist legal critique must therefore attend to the semiotic dimensions of legality, how criminality works in excess of law books, how it names, how it circulates meaning through our bodies before it ever reaches the courtroom or appeal, how perceptions of criminality help launder colonial violence and quell the development of alternative grammars of recognition and care.
This did not make it easier. I think we're on a journey, and I think there's already so much on the table. We could have a great conversation, so I feel a little humble to even try to add something. But I, I'm an obedient lawyer. No, I'm not. So I think how law matters to gender and how gender matters to law, as we saw now, may be a political question. And there it matters. It might be an ideological question, and there it matters. It may be an analytical endeavor, and that's, I think, what Nikki emphasized quite a bit. And it may be something legal, a real legal problem, there it matters. And it may be a real problem for people. And that's what I'm going to emphasize, and there it matters too. So I think it will be important in our conversations to keep this a little bit apart. What are we talking about? Political uses of law, or application of law, is it law, et cetera, et cetera. But what I first want to say that, all I'm going to say will be overbroad, and I will say law or rights or courts or things like that, despite the very fact that there's a wide, huge variety out there of what law is and courts are and practices are. And so the first remark is that in everything we're talking about, we have to be really careful to look for context and legal forms and institutional design and the life experiences that we're in fact then already always also talking about. And with context, I mean primarily that space and location matter to law, that time matters, the politics around it matter, including the economic politics, the relationships in which law is one factor of dealing, interacting with each other, the assumptions, like an assumption of innocence, matters tremendously, and they are culturally different, and the bodies that are kind of on the scene when we look at law. So context matters, and then legal form and institutional design matters in that the words differ. So when we talk about law and criminal law, you may talk about UK criminal law, which will differ from other types of criminal law. And that, I think, is something to take into account. When we're doing theory, it's totally okay to, typify and summarize. But when we're then engaging on the level of politics and on the reality of people's lives, then we need to be aware of the fact that legal form and institutional design matters tremendously and differs tremendously, as in words, the levels of regulation, and there may be a local rule, formal or informal, there may be a national rule, there may be a transnational or international rule, And regarding international rule, it may be human rights, but it may be a very weak form or a very strong form. There may be a court behind it or not, etc., etc. You know that, and there are different levels of institutional backup for law, and legal cultures then again surrounding it or forming its practice. And then the third point on context is that I think life matters. What are we talking about when we're talking about the injustice or the inequality or that thing or that phenomenon we do care about? Why do we engage in this conversation? There is a sense of something happening somewhere which is unjust or harmful or a violation or a discrimination as inequality or a vulnerability that should not be exploited. These are very different ideas. And I think they produce different images, at least in my head, but I think in people's heads, on what are we exactly talking about? Do we talk about a sense of belonging? Do we talk about blood? Do we talk about a violation of the body, of the psyche, of the political status, of what? And I think whatever topic we address, it will in some ways inform what kind of injustice you have in mind, what kind of, say in the classic terms, sex inequality you have in mind, what kind of injustice to queer people, black people, trans people you have in mind. What is your paradigmatic case why you would actually even start thinking about this? What is the paradigmatic injustice? Because I think that does a lot to how we think. And we saw criminal law, again, a criminal law and police law, to me, a public lawyer, police law example. I had the pleasure for 12 years as a justice to engage with every area of law, but always from a fundamental rights perspective, human rights, fundamental rights perspective. So that will do something to my take on these issues. So that's the preliminary. Whatever I'm going to say now has to then be qualified in relation to all these different levels and problems, et cetera, et cetera. But what I then want to say is what's interesting to me is that this conversation starts at an interesting point, and Nikki mentioned the point as well, with referring to Carol Smart, the British sociologist who talked about the siren call of the law, that singing of the sirens, and then you are smashed to the rock, a dangerous thing. And to me, it exemplifies a trend in many radical movements, including feminist movements, including queer movements, saying, you know, the law? No. Are you kidding me? Oppressive, criminalizing our lives, prohibiting abortion, you know, the whole thing, never delivering anything, so why the law? And Carol Smart's analysis is a good read still. It might seem really old to many of you, but it's really a good read. And that she's also about a movement engaging with that and why and throwing back and forth the arguments. And then Audre Lorde's quote of the master's house will never dismantle the master's tools will never dismantle the master's house is also a very well-known one. And I said this morning, keep reading. I mean, read the whole text, because Audre Lorde is not an anti-law person with that statement, because she qualifies her statement in her text. But again, there was a time, and in many contexts, countries, movements, where law was really not the most interesting or tempting or attractive thing to engage with. And I think today we have reasons again why it's not interesting. Well, it's interesting, but it's not attractive. But we here started with, you know, it somehow is there, and somehow we should spend an evening on talking about this. So there must be something. And so I think what we're building on is that many feminist legal theorists, queer legal theorists, critical race legal theorists, etc., insisted on the potential, at least, of the law. The potential, not the automatic delivery, but the potential of the law. First and foremost, equality. Or for those who are into liberty, thinking liberty, you know, however you frame it, it's about emancipation. It's about freeing yourself from a lack of freedom, or equality as the promise to really be equally free in a society that promises that. So we're working with the potential, and I think it's noteworthy that we're starting with the kind of, at least that was my impression, with the kind of, I was not totally sure, but a kind of affirmative stance of, there is at least something, we cannot discard of it, and we cannot totally forget about it. So there's a potential. Catherine McKinnon called it the crack in the wall, and her point was there is a wall, and law is a wall, and we are basically actually not stumbling into that wall, we are kicked to the wall. And people throw us to the wall, and we're hurt, and it really hurts. But there's a crack. And for her, the crack was equality, substantive equality. And that's why she said, if you crack a wall and you put wood in it, and you burn the wood, and you wet it, and you burn the wood, the wall crumbles. So I think that's interesting to note that we are starting with that. But then all of you and I myself think of gender studies and law, legal gender studies, as the most advanced approach to understand the ambivalence of it. Not only the potential, but the ambivalence of the law. Sometimes even the cruelty. Ambivalence is a very nice term. And sometimes law is cruel in that it does not recognize you as a human being or your identity, or in that it allows for violence being exerted on your body, or that it, does various things. So maybe Nikki's example of, the assignment at birth is the foundational injustice of the law in relation to gender. Maybe that is the foundational injustice. And I'm happy to say that I'm part of a court, the German Constitutional Court, who said at some point that is an injustice. If you force people into two boxes and they're not in either one, this is a foundational injustice to people. It violates their very foundational rights, namely dignity. And you have to open a third box. That's what we said. But my favorite little clause says, and the legislature could do away with boxing. It's in the ruling. That's the very important one. And, we were 8. I was not the only one. If I would rewrite it as a feminist judgment, I would maybe get somewhere else. But so we're engaging with the potential. We're engaging with the ambivalence of law, sometimes being cruel, ignorant, oppressing, etc., but then also can allow for space, create spaces. Law is also an opener. Law is also a distributor of resources. Law is also something that gives voice and agency. So it always has both sides. Law can be utilized to install or manage or legitimate both injustice and justice. And I think that's what we're facing. And again, my call will be to be precise when we're looking at this. What exactly, which law, on what level, at what time, in which context are we looking at, and what is exactly the effect on things. However, I think we're doing this at very different, in very complicated, and very challenging times. Because we cannot have this conversation, I think, without looking at what is done to the law and with the law these days. I mean, right now. And not only in the United States, in case somebody would think of that president right now only. Sadly, it's not only in the United States. It's happening everywhere, and it's been going on for a while. And for continental Europeans, Brexit was a one step along that road. And there are many, many more steps these days. And so what I think is, when we talk about gender in the law and the potential and the ambivalence and all of that, we also have to be aware of the fact that there's a struggle going on, ein Kampf ums Recht. It's one of the legal sociologists, a Viennese guy, who said that in 1905 already, the struggle around law, the struggle for law, the struggle in and of law, in that we see too many people who do not care anymore, who simply do not care. The new sign of power is that you do not care. It's not having it. It's like, I don't care. Do it or not do it. It's like, I don't care anymore. It's the same with knowledge, by the way. I don't care for the truth. I lie or I don't or whatever, but I can do what I want. That's the new sign of power. And that's a new situation. And we see many, many people, governments, actors, all kinds of people. Also, maybe people, just people we know, who ignore the law, circumvent the law, and break the law. And the big breakers are certainly Putin, waging war and totally ignoring any international law things. Many wars right now ignore the international law requirements, including Gaza. And so there's a fragile state of the law. And so when we engage in very critical, discussions of the law, and I think this is a context, that's why I started with context, we really have to take into account. There are people out there who want us to discard of the law, ignore the law, not really care for the law, say courts are really, they're really a problem. bunch of old white men or whatever you think, which is basically a conspiratory theory and not a good idea to criticize courts, but whatever. So this context today is that the law is in a bad state. It's targeted, it's deliberately targeted, it's ignored, it's broken, et cetera, and I wonder, and it's a question, I wonder what this does to our critique. I wonder what this does to our dealings with the law. Finally, I say this because I think this matters to people. I started with, law and levels and but my whole point, my whole engagement with the law is because it matters to people kind of in life, on the ground. That's what I care for. And whatever I think gender can do to legal discussions, and legal discussions can learn from gender, is to have this very realistic, and I mean realistic, view, take on what does it do to what does my take on law, my critical apprehension of law, what my theories of law do to people on the ground. And again, I'm at your paradigmatic case in the back of your head. What do you care for? What is the injustice you care for? And so I think what we need to be doing is to be very, very precise when we talk about the law these days, because otherwise we're at risk to, having the wrong bedfellows. When I would stand up and give a talk on the rule of law, really problematic, patriarchal, and some people would be really excited, but the wrong people would be really excited. When I think, awful controversy around trans rights erupted in many, many countries, here as well, many people were excited, but very often the wrong ones, because the women's movement took itself apart on things in very, very, I think, cruel and outrageous ways. But that was a discussion where I thought, how do we discuss things these days? Are we falling for a stick, for a carrot somebody else holds there? What is happening there? So I think to engage the law and gender means to understand the law really well. Think deeply about it, you said that. Take it apart and remodel it. And so when Nikki said, talked about criminal law, it's really about how exactly criminal law can be used towards justice. How exactly criminal law, on what level, with what kind of norm, in what institutional design, in what context can it be used? And with your very intriguing analysis, the question would be to me, what exactly happens when the law criminalizes queer, black, non-conforming people, trans people? Who is the law then? Is it the rule, the procedure, the police officer, the lawyer, the court, the observer, the reporting media, and producing a narrative of what the law is, and thus producing a normality and a deviance? What you're the expert, I'm just I'm just phrasing the question I had in mind about this. What exactly is the law? And we need to be critical on that, and nuanced and detailed and all of that, I think. But at the very same time, because it's 2025 and the rule of law is going down the drain all over the place, be very sure that we do not discard the baby with the bathtub, right? That the rule of law as a democratic rule of law, not any rule of law, that's what my piece was about, not any rule of law, but a democratic rule of law, is about accountability, is about unleashing the potential, the crack in the wall, make it work, is about being beware of the ambivalence, but working with it constructively, and do law. Thank you.
Thank you, Susanne. Okay, so now you've all been very well schooled in all the difficulties, complexities, ambivalences, potentials of law, and also what law does to our lives, but also how we can frame our critique in light of all of this. difficulty. So I'm actually going to ask each one of you, because I've got you here, so I can do that, right? So I'm going to ask each one of you something that I've been absolutely dying to ask since we set this up many, many months ago, which is, in light of all the difficulties and complexities and ambivalences and potentialities and erasures that you've spoken about today, how do you envision a productive working relationship between gender and the law? What would you like it to look like? That's my question to you. And I'd like you, I mean, you can pick it up the way you want from each other's, interventions, or you could take it in any direction you got, but we've got about 10 minutes for this, so yeah.
Are we going in order again?
No, you can jump in as you like, yeah.
You think I have to start now because
No,
I have
no,
the
no,
privilege?
no. As usual, got plenty to say.
Okay, I mean, one productive way of engaging gender in the law is tonight. So that's to me a productive way because, I mean, we're spanning methodologically quite a range here, and I think the willingness to do that and the willingness to not say, oh, it's semiotics, what does that have to do with me? But that gender studies trained me to remain curious, even if I don't get it at first hand, but to start taking it in as at least irritating my concern, and that is I think something to be said, and second, I would refer to something Nikki's also teaching here in her feminist legal theory course, which is feminist judgments, because that is a movement that lawyers founded, but it profits from, academically speaking, interdisciplinary interventions, but practically and activist-based speaking on engaging law cases, rulings from very many perspectives, and kind of revolving around the law, but not being trapped into the law, but constantly expanding and thinking like, what could not be said? My favorite question with rulings, like, what is not in there? What is not in the law? What is outside and what makes people suffer, which is always then my key concern. And so I think that even methodologies out there, this is activism, but this is also a methodology worldwide by now. The Brazilians did it during COVID online, great projects. We're just starting it in Germany. There are many, many projects around the world. Makes people who are not lawyers kind of not lose respect for the law, but just read it, which is also not anything being taken for granted. I don't know how many of you don't study law, just take rulings and say, well, let's look at it. No, I like it or not, and blah, 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 blah. These texts have a status and a standing, and so to start really engaging with it, but it also forces you to be really detailed in your critique, and it allows you to decide whether you want to be kind of more pragmatic or strategically utopian or where you want to go, but it makes it very clear, it puts it right there on the table. You see the consequence of your calling right away, and I think so that I think is one of the very interesting methods to connect.
Thank you, Sumi. Well, thank you both. I love listening to your interventions. So I guess I'm going to do that typical lawyer thing of making some distinctions.
Yeah.
Oh dear, I'm sorry. It's a kind of déformation professionnelle sort of thing. But I think how you conceive a productive relationship depends on which sphere we're talking about. So I completely agree with Susanne that things like this evening are an intervention, and on that level, I conceive my sort of trying to teach gender across the curriculum as an intervention on that level, not just in feminist legal theory course, but trying to bring it into other courses and try to use our feminist legal theory course as a way of building resources for the whole law school and anybody else who wants to self-enroll on our site. We've got a great site with big reading lists, gender and popular culture. So, we try to do that, as I know you do in the Gender Studies department. But then feminist judgments, certainly, and just recently, and this is not my idea, by the way, so I can't remember whose idea it is, but I recently read a very interesting sort of outline for research on feminist legislation. So what would it take to rethink how we make law from a feminist point of view? I think the Feminist Judgments Project has gone a long way to helping us think through about the interpretation of law in the courtroom. But at every level, all of these different levels of the way we think about law, teaching, how we teach law to school children, at all these levels there are ways in which we can basically raise awareness. I think that is all we can do. Now, I'm very persuaded by your argument about the semiotic power of law. But I think the only thing I would caution about in the way we think about the answer to your question is let's be realistic, certainly, about all the grim ways in which law has constructed what we mean to each other and ourselves all too often. Not to mention, how power shapes our lives in various ways. But let's not entirely, and let's be realistic about how it's going to be very, very hard to change that. But let's look for the crack. I think that's the key thing. So let's think about how we, at every level, educate, learn about, make, interpret, enforce, change law. Let's think at every level from, let's make sure gender is in there. Yes.
So I think I come to this question from a different angle, obviously, both in kind of my training, my background as a sociologist, working initially in criminology and then moving to gender studies, which has been a very expansive and generative kind of opportunity. And I think what I want to do is take this question and think through, what does gender studies do to my understanding of law and how I approach law? And I think the second entry point that I'll name is I was an abolitionist organizer at the grassroots level for many years, for about a decade before moving here. And I think one thing that I've always found really important, I think names the kind of ambivalence that you've both brought up in your talks, is know your rights trainings. And I just think it's a really great space, right? It's a good site of analysis for why I've moved the direction of my critique out of the maybe more specific, vantage point of the text. Now, with know your rights training, it's oftentimes very important for people in the sense of the empowerment that they feel when they're engaging the police or ICE in the US context. And yet the number one kind of point of pushback is you don't have those rights if you have certain embodiments, and we see that in every kind of level of the interaction with quote unquote the law. So we'll say the law in this sense being the people, right? How the police are the law, right? In that kind of symbolic way. But then also with the way that law is manipulated
and or produced in response to certain bodies. And it's constantly refashioned to the political kind of moment. So a Know Your Rights training that I sat in on, there was one person there who was, Spanish speaking, but American citizen. And then there was someone who was a European immigrant. But via Canada. Anyways, I'll just say that person actually was undocumented, and the other person was a citizen. And when we gave the Know Your Rights training, it was such an interesting moment in which somebody said, yeah, but the second I said that, they assaulted me. Like the moment that I tried to articulate my rights, right, my knowledge of the law, etc., I was assaulted and arrested. And the other one said, oh, that never happened to me. They never checked my papers. You see, in the same exact incident. The reason why I'm curious about this, now obviously I did, I thought through the meta language of criminality and, this talk in relationship to queer and trans Black people, and I'm very interested in taking that further. Not to say that that's the only kind of, body that's marked as the criminal body. What I think gender allows us to do as an analytic is to stay faithful to the questions of how power works on the interpretive level of law in various spaces, some of which are by the people who are meant to enforce the law, some of which is on the experiential level when you are or are not detained or trafficked en route to a legal decision. These have really severe implications on people's lives. And so I think that what I am interested in and what I think how gender matters to the law is really enabling us to fill out our methodological interventions that are possible for understanding what law may be necessary, what law is functioning, how law is functioning, and what types of interventions we need on the social levels in order to actually actualize justice. So I have a lot of kind of different examples with this, one of which I was in response to what you had said around sexual violence and sexual abuse. But I feel like I don't want to take much time with this. So I just wanted to talk about it.
Fantastic, fabulous. Okay, so I'm now going to open
May I
the.
ask a
Yes.
little question?
No, go for it.
Does it make a difference to think about your example as they violate my rights opposed to I don't have that right? I'm referring, I did a lot of training of all kinds of people, including police officers and survivors of domestic violence. And I learned it from them, that they said, I said, and in that situation you didn't have that right. And they said, I did have that right. They violated it. And then to get into what you said, actualizing justice, then they got into a discussion of like, what kind of social resources do I need, or what kind of legal help do I need, or whatever do I need to actualize my right. And to do this, I need to understand how far my right reaches. Maybe it doesn't cover everything I want, but I think there is that shifts the conversation a little bit.
And I think that the kind of terms of legal empowerment, right, that has a really great impact on the individual level. And yet it stifles our idea of what justice is because it limits it to the formulation of kind of actualizing the right. So, it's not that, I do think that subtle shift, I understand why that's actually really powerful, especially from the person who's experiencing on a singular level. On the collective level, I'm really interested in how perhaps a different formulation of rights is something that can be collectively built and sustained, right, by community efforts. And in my experience, those have been largely led by gender and sexual minorities.
No, I'm done. Let's go to Q&A.
I'm going to distinguish between rights, law, and justice. Because what we're getting at is you don't have the right to, they violate your rights, which may not mean justice. You know, the idea of justice, the actualization of justice may be way more. And so to escape that limitation, that legalistic limitation, I need to differentiate between rights, law, and justice, and the broader communal sense of whatever. Yeah, thank you.
Okay,
Sorry
great.
to take up your time.
No. This is great. So I'm now going to look at you, okay, to see if you would like to ask a question. So that's why I want to look at you. So and all you have to do is raise your hands, nod at me, whatever you like. So, but I'm going to collect some. Okay, so I'm going to be democratic. I'm going to look for like 1 minute. 10 seconds here and 10 seconds on the other side. So. Yeah, so and I'm going to collect a few. So I see 2 hands, and I'm going to go, and I see 2 hands there, and I'm going to take 4 questions in the first, and I'll take 4 questions in the first round, and I'll come back for the second. So there's 2 questions right here, where you stood, Nila. Yeah. Yeah, those 2. And one, and then after you. Yes.
Okay, I'm going to try and make this as very
And
brief as possible.
And can you, when you ask your question, could you say very quickly who you are? Not existential conversation, just really, really quickly who you are, and then proceed with as brief as possible.
My name's Grace, and I'm an LLM student from Australia. My question is in relation to constitutional interpretation, and I think perhaps Professor Baer and Professor Lacey can answer this. And of course, Professor Rodriguez, if you have any insight as well. Do you think there's scope in interpreting the Constitution for courts to have regard to the fact that constitutions were drafted at the exclusion of certain people and certain groups? And in my mind, I'm specifically thinking about the first and second abortion decisions in Germany, Professor Baer.
Thank you very much. And next to you, there was a question.
Where?
Oh, sorry. I'll stand upstairs and see me. Hi, I'm Sophia. I'm a gender studies student and from the United States. And my question is particularly for Dr. Rodriguez, although I'd welcome anyone. But your remarks really made me think about an active court case that's happening in the US right now surrounding the Trump administration's ban on trans people serving in the military. And just for a really brief summary, largely how this has been, going through the courts, and it's still being contested in the courts. But one of the arguments that the Trump administration is making for why they are trying to ban trans people from serving in the U.S. military is what I would argue the blatantly transphobic and insulting logic that they are saying that to be trans is actually immoral, and that it represents, means that soldiers are not representing the honor, like the values of honor, discipline necessary to be a service member in the U.S. military. And so I think a lot of that aligns with what you were saying, Dr. Rodriguez, about this assignation, not just of what behaviors, but actually of who you are, and this framing of morality around a gender or sex identity. So then my question really comes to, okay, this is now, we have one organ of the state being the defendant in court, which is obviously another organ of the state, and in some cases then you're dependent on the personal views of the judges that this case is going to go forward.
Thank you. So, and then there were two questions here. Yeah. So right in front, and then after you. Yeah, 2.
Sorry, I'm coming.
Okay, and could you please keep them really brief so we can get a whole round? Thank you.
Hello, my name's Emma. I'm not a student here, nor have I ever been. I work for a family court nonprofit. Yes, I wanted to ask sort of anybody what your thoughts are on the recent amendment to the crime and policing bill surrounding criminalizing retaining a child abroad after they go on holiday.
Thank you very much. Yes, please. And right at the back, yeah.
Hi, my name is Lillian. I did my master's here in 2022 in gender and policy. I wrote my dissertation on the Dobbs decision, the overturning abortion. And so my question is also about the Constitution and about how the patriarchy can be a part of the law, is the law often, anyways. But how to fight like originalism and the validity that's given to the patriarchy, especially that decision that the findings of my dissertation basically were, yeah.
Thank you very much, thank you. As you see, we've got 4 questions, and I think you could take them as you see a couple of questions on constitutionalism, and then a question particularly on the US case. So do you want to take the question?
Actually, I'm going to take the question on the amendment to the Crime and Policing Bill on criminalizing abduction. So I'll start with a basic kind of anti-carceral feminist stance on criminalization. So criminalizing international abduction, and in that particular instance, what you're referring to is the unlawful retention of a child rather than unlawful removal. Those are 2 distinct kind of parts within international parental abduction, and one of which was already criminalized, the other was not. So the push to further criminalize, I'll say there are, so the attempt, right, with any criminal law is to signal the kind of severity with which that state handles this problem, right? And I think family law, especially international family matters, because once you cross a border, that, like, states treat this very, very differently. So England attempting to say, we are going to criminalize this, is England's attempt to say, we take this very seriously, we understand that this is cruel, that this hurts children, etc. And therefore, we're going to treat this the way that we treat other instances of violence against children. Okay, great. The other element of this, though, is that when we're talking about oftentimes, you know, the feminist approach to kind of violence, an anti-carceral feminist approach at that, understands that there are counter-deterrent effects of punitivism. What happens with criminalizing unlawful retentions, while it signals that kind of severity, it also, one, decreases the likelihood that someone would voluntarily return, right? Because criminal sanctions are harder, and you don't want to return to being to punishment. But the second element of it is that it makes it more likely that the states that do not consider this a criminal matter, but a family or a private matter, will not participate, right? Because they believe that's fundamentally unjust, and oftentimes when we're talking about international parental abduction, of course it hurts a child, but it is something that is disproportionately achieved by women, by mothers. And so you have this kind of difficulty with what domestically is, you know, the attempt is, and what internationally it's actually communicating. So, I'll think on this other one.
Yeah. There were 2 questions actually, which were pretty much around the lines of, should we reform the Constitution? It seems to be large questions. So there's a question of originalism.
Am I in London? Which constitution?
Well, the German Constitution is
So yeah, I mean, these are very complicated questions. So let me brief points. One is on originalism, right? A very, very American outlier to the scene. Internationally, professionals, as I might want to say, pretty much know that this is naive, if not totally ignorant, as to the problem of sources and historization. And I think there were some amicus curiae briefs in America to the United States Supreme Court by historians that clarified that point. And the point is, history is inconclusive. There's history, but it's inconclusive as to the interpretation. And so I think there are strong arguments against originalism. Second, autocrats are extremely good in remoralizing the law. That also goes to the trans point. And I think that's very interesting because wasn't it us? I mean, wasn't it feminists and all those who moralized the law? But now, in fact, it's autocrats, particularly nationalist, racist autocrats who remoralize the law. And I think that's something I would have never thought of myself defending the liberal kind of distant kind of neutrality of law, but now I do. Because this moral kind of infusion is way too big. Sadly, judges are not per se immune to this. And we see in many courts that the deliberate attempt to undo democracy starts with placing people there who, in my community of judges, we think are not judges anymore. They are crusaders, missionaries, whatever, and actually Justice Scalia, who passed away, and an American judge who is the promoter of originalism. When you read his books, this is Catholic missionary ideology, and that is really, and I still am pretty angry when law professors teach his dissents as so interesting and so sharp. It's for a German, whoever knows that scene, teaching Carl Schmitt is really interesting, who was the prime Nazi jurist. And I think you have to engage with these people, but in a way more critical sense. So that autocrats moralizing the law is something that's happening there. So is there space to undo that and to undo patriarchy in constitutional law? Yes, sure there is. What else can I say, biased as I am, but I think there is, and engaging comparative constitutionalism, you see that in South Africa in the first phase of the constitutional jurisprudence there, in Canada, very, very eminent judgments, not always, not like this, progress is not like this, but it's, there are valleys and there are mountains and it goes up and down. But there are many rulings out there, also in some of the Eastern European countries, very courageous rulings. I might want to say that some of the German rulings are pretty okay. So there's a lot of material out there where the cracks have been identified and things have opened. And I think the most immediate parts, I said that earlier in class, are to look at remedies courts design in Latin America in particular, in South America, very, very creative, very interesting, very interventionist, but also careful in not replacing politics, but kind of pushing politics. So that's really something, because courts are always only your safety belt. Courts will not do it, right? Courts, particularly constitutional courts, will, throw the ball back into the field, and then it's all of you playing ball. And so yeah, but I think there's a lot of space in the remedial part, in the assessment of facts part, in the inviting different voices, in doing epistemic justice to things, to experiences, something that sorry to say the Supreme Court of this country did not really do when it decided the gender case, because established voices in the field were not heard, were not invited. That, whatever you think about the judgment, but that's a very basic failure in the legal system. But again, the advantage of the law is that this is not just an opinion. I have a legal claim to make that this was a failure. This violated, I think, epistemic rules of procedure in a court, and that's the advantage of the law. So yeah, there are many cracks and potential to undo it. Yeah.
Okay, so I agree with what each of you has said in relation to the questions you've addressed. So I'm going to add something that's sort of oblique to several of the questions and also speaks to your argument, SM. But it also picks up on something that we've been skirting around, which is the context of growing autocracy and authoritarianism and threats to law. So our job is to be critical scholars of law. Of course it is. That's why we're in the academy. We wouldn't be here if we weren't here to be critical. But in the proper sense, in the intellectual sense. But I think I also want to put on the table that in my field of criminal law, I would say, there are lots of different ways in which law has, over history, organised its patterns of attribution of responsibility. And one of them, unfortunately, is character-based attribution, or perhaps a more modern way of putting it is risk-based attribution, which is actually fed by implicit assumptions about character. And I find that absolutely pervasive over criminal law. And a lot of my work over the last decade has been tracking, unfortunately, the resurgence of those character-based mechanisms of attribution in the English legal system. And I think the English legal system is not, alas, alone on this. And so I think when we critique law and we see it's, the dangers and the sort of semiotic violence it can do, and I take that idea very, very seriously, and the problems of sort of embedded patriarchy and the structures of constitutional courts and constitutions themselves, we've got to also be very attentive to the fact that there is a context here, a political context, which gets better and worse. And at the moment we're in many countries heading into a worse bit. And I think pragmatically, as feminists and critical race theorists and activists, we need to be very attentive to that context, is what I want to say.
Can I have a tiny remark?
Yes, absolutely.
The immoralization, the moralization of trans people, it comes pretty directly from a encyclica of the Pope, where an interesting shift happened. It was the former Pope, but it stated that gay people are, a problem but should be tolerated. But trans people are a sin, which I think is one of the most cruel statements from a religious source I ever saw. But that's one of the important sources, and nobody should ever underestimate the strength and willingness of the Catholic Church to act politically in these realms. Reproductive justice is the other big field, but that's the new line, and trans is non-conforming women. They're pretty loose in their definition of trans, but because it hits on people who do not oblige with heteronormative models. So I think for a long time I did not name these sources because I did not want to offend anybody who's a believer and and by now I think I'm moving into let's name them, expose them, engage them, because it's a tough one.
If I could address that, it did be, so it's funny because you brought up the smart quote, the siren call, and I think it's so interesting because, obviously this is going to be a through line here with so many of our comments, but I do think that this, I could take your question on in a longer way if you want to book office hours. But what I will say is what that is about is how liberal legal achievements actually secure the demise of liberatory ends. Fundamentally, when you take trans populations, trans people, you are able to see what is articulated as the coloniality of ability and the coloniality of gender meeting each other in a politic at play here. And what's happening when trans people are integrated into the service of, the military of the United States is that they are being integrated as a kind of people who are newly permitted, right, for inclusion, in a way that obscures the fact that fundamentally to be trans in the United States is to be pathologized. The only way to legal recognition as a trans person is to be diagnosed with a disorder, to be funneled through a very specific transnormative medicalized process, and then join the military. So do you see what I'm saying? Like, it forecloses so many pathways of understanding what transness means and has historically meant throughout the world to create an actual category, an identity category that is reified by law and legal recognition that fundamentally rests on an idea of trans people as disabled, right? Disabled people have been and always will be, right, banned from the military. So what does it mean to achieve this inclusion, right, while at the same time, like, further naturalizing the otherness of disabled people, right, of the irrational person? Those are the kinds of questions that I think are, you know, well, at least what I would like to take up.
Okay. Okay, everyone. I was very optimistic that I'd be able to take another round of questions, but I can't. Our time's up, but and this conversation is ongoing, right? That's been established that this conversation is ongoing, and we need many, many more of this. And our panelists have taken us to a wonderfully generative and productive place with their glittering talks. So can I please ask you to give them a round of applause?